Hey guys, this is attorney Philip Adams with the law offices of Philip Adams in Shreveport, Louisiana. And I want to take some time today to talk to you guys about some potential impacts that may arise from a driving while intoxicated conviction in a simultaneous civil suit. In Louisiana, if you get convicted of driving while intoxicated, your conviction could carry great weight in a civil suit stemming from a car accident arising from you being drunk while driving. I want you to consider a hypothetical fact pattern to illustrate what it is that I'm talking about. Suppose drunk driver A gets into a car accident with sober driver B. While being drunk doesn't necessarily mean that a driver is at fault in a car accident case, let's assume in this hypothetical that driver A is not only drunk, but is also completely at fault in this car accident. And this accident was caused by driver A's intoxication. Suppose that driver A is prosecuted for this DWI in criminal court and then convicted of driving while intoxicated for a first offense under the Louisiana Revised Statutes 14:98. Which would be a misdemeanor in Louisiana. Suppose that sober driver B was hurt from this same accident and then brings a civil personal injury lawsuit against drunk driver A for property damage and for personal injury damage. What are some potential impacts that drunk driver A might experience as a result of this civil personal injury lawsuit? Well, there are multiple potential consequences that could flow from the conviction against driver A. Probably the most obvious one would be that the conviction could be used against driver A in civil court in the pending lawsuit. Now, in criminal court, a prosecutor does not have to show that a car accident occurred to obtain a conviction from drunk driver A for driving while intoxicated. The prosecutor only has to show that the driver was operating a vehicle while under the influence of alcohol and/or drugs. And Louisiana courts have interpreted that language under the influence to mean basically having one's ability to operate a vehicle being impaired at the time of operation. In criminal court, as always, the burden of proof is proof beyond a reasonable doubt. This is the highest burden of proof that we have within our legal system, not just here in Louisiana, but in any U.S. state. Before the government can strip someone of his or her liberty, our society demands that there be enough evidence brought to bear against an individual and that the evidence has to be overwhelming enough to firmly convince a judge or jury, depending on who's the trier of fact, of that person's guilt. In our civil system, in contrast, the burden of proof is actually much lower and is generally going to be by preponderance of the evidence in a civil matter. And when you're talking about a personal injury lawsuit flowing from a drunk driving incident, the burden of proof will be proof by preponderance of the evidence, which is basically the plaintiff has to show in the civil suit that there's more evidence than not in that plaintiff's favor. So if you can show that more than 50% of the evidence is in your favor, then you can prevail in that civil suit. The evidence doesn't have to be overwhelming or clear and convincing to meet the burden of proof in a civil suit. It nearly needs to be by preponderance of the evidence if you're talking about a personal injury action flowing from a drunk driving incident. Will this evidence of intoxication be enough to show fault for an accident in a secondary civil case? Well, if the intoxication that caused driver A to get into an accident with sober driver B, the evidence flowing from the criminal trial against driver A could be used by a competent civil attorney to easily prove fault on the part of drunk driver A in the secondary civil case. The civil attorney could request a copy of the trial transcript from the criminal proceeding, read through that, see which witnesses were subpoenaed and brought to court, see how they testified, and then could easily attempt to replicate the same record in a secondary civil case, especially if a trial is brought. Because if you can meet proof beyond a reasonable doubt in a criminal case, then you can certainly meet proof by preponderance of the evidence in a civil case, all things being equal. Now, there are other consequences that flow from a conviction against drunk driver A in criminal court in the hypothetical that we're talking about. So, for example, driver A could have what are called punitive damages brought against driver A because of the intoxication that led to the car accident. And punitive damages are designed not necessarily to compensate someone who's injured in a car accident, but rather to punish the other driver because of egregious conduct that other driver engaged in. And the Louisiana legislature allows for punitive damages in drunk driving scenarios. And it allows for that as a public policy measure to try to disincentivize drunk driving and reduce this scourge that exists on Louisiana's public highways. And so I say all that to say that drunk driver A's strategic options could be severely curtailed if drunk driver A gets convicted in a criminal court case and then later is facing a secondary civil personal injury action flowing from that same drunk driving incident. So it's extremely important to have competent criminal defense counsel defend you in a pending criminal case involving a DWI, especially if you know that someone got injured as a result of driving while intoxicated. Because if you can minimize the consequences or potential for conviction in the DWI case, then you can potentially also minimize the consequences that might flow from a personal injury action as a result of that same driving while intoxicated scenario. You might not be able to minimize consequences, but the odds are probably going to be higher if you can mitigate what's happening in criminal court in an effort to mitigate what may potentially happen in civil court. So if somebody you know is in need of criminal law help or help in fighting a pending civil suit or help in bringing a civil suit as a result of a personal injury action, it's very important to have competent criminal counsel and, I would argue, competent personal injury counsel if an individual is facing a driving while intoxicated case in Louisiana. Thank you.